gun lawyer.
So the first question we got that I thought I would address is from, and you have to forgive me if I mispronounce your name, but I believe it's Jorge Mora, and he basically asked, how do I carry a firearm as a concealed handgun licensee if I want to drink alcohol? Quite honestly, you don't. You shouldn't do that. Guns and alcohol do not mix. Before I talk about the law, I want to make that exceptionally clear. Do not mix guns and alcohol. It's not a good idea. You're going to have a bad day. So at the end of the day, though, there is a law against it. It's a first-degree misdemeanor if you're using weapons while intoxicated. That's the name of the law. The actual elements of the crime talk about using weapons while under the influence. Generally, what under the influence means is either what we call a per se violation, which is over a .08 if you blow into a breathalyzer. Or you can get what we call an impaired violation, and this is generally speaking with regards to OVI law, or operating a motor vehicle under the influence of alcohol, but I think it's still applicable to firearms because it uses the same terminology, under the influence. The impaired violation basically is what the officer perceives. It's the smell of the alcohol in the car. It's the walk the line test, or what we commonly refer to as the NFST's National Field Sobriety Test. The nystagmus gaze test with the pen they do with your eyes, see if your eye is twitching. All of these things. So theoretically, could you have a beer, have a gun on you? Again, I'm not going to tell you yes because I think it's a horrible idea. But the law is clear that you have to be under the influence. So again, don't carry a gun with alcohol in your system. And I tell my students when I teach, even if there's the chance, even if you don't intend to, but there's a chance of wherever you're going that you might drink alcohol, don't bring your gun. It's not worth a felony charge. So with that, remember, be safe out there and carry on.